So we've talked about the fact that uh, the various parties that act on behalf of the corporation are agents, right? And we know that there are a number of duties and responsibilities as well as rights that attach to that, right? The the next topic we're going to deal with is directors, right? What they are, right? And how they fit into this whole puzzle of corporate governance, right? So directors, when I say that they are the managers of the corporation, I mean that in the same sense that they kind of are in the place of the managing partners in a partnership or the general partners in a basic partnership, right? They are collectively responsible for the operation of the company, but they don't execute anything, right? Because that would be them acting by or on for or on behalf of or instead of the corporation. That would cause agency to arise in their individual capacities, right? So what is it that directors are? They are the ultimate decision-making authority within the corporation, right? So they're like mommy and daddy, right? What they say goes. They guide management. They also hire management. They supervise management, all right? And the board as a group is an agent. But individual directors, unless they are acting in some capacity as in some capacity other than making collective decisions, right? They are not going to be regarded as agents for this purpose, all right? So directors are generally required in corporations by state statute. Many jurisdictions will require three. In some jurisdictions, only one director is required, but in any event, someone has got to stand in that fiduciary space with regard to that corporation because the shareholders, as we indicated, have their limitation of liability is absolute, right? Unless they're acting as agents of the company, right? Um, in fact, they're not liable to one another, and they're certainly not liable to the company, right? Uh, Directors may be, but need not be, shareholders. What does this mean? Well, for my purposes, like what I'm trying to get across, this means that a director who is also a shareholder is not a fiduciary in their capacity as a shareholder, but they are a fiduciary to the company because they are a director. So they don't have the same limitation of liability doesn't have the same impact upon them as it would upon a shareholder who is not a director, right? What this means also is this underscores the importance of directors and officers insurance because we are only human and we certainly can make mistakes and become liable for things. We'll learn that in Business Law 1. Few states have very many specific requirements, even with regard to age, right? You can have a child that serves on the board of a corporation. In fact, children have done it, so especially in family-based companies. The the requirement is that the person be willing to stand for the responsibility that comes with that board, with that board seat. Uh, the initial board is generally appointed by the party that incorporates the company. After that initial board is appointed, there are elections, and those elections will be, as well as the term of that board membership, will be set by the articles of incorporation and by the bylaws of the company. And remember, the articles of incorporation are the sort of like the constitution of the company. It sort of puts it together, right? Or it composes the company and it makes it statutorily legitimate. And then the bylaws govern the corporation, right? Again, as I said, board action is collective, and in that capacity, the board is collectively an agent, right? But if and only if a director acts individually in an agency capacity, then a specific director may be an agent, all right? Elections, 1 year is typical for terms of elections, right? For a director election. And then the elections are generally held annually among shareholders and large public companies. When we get to shareholders, we'll talk about proxies and how that works. In small companies, it may be, in fact, simpler than that. The You're not necessarily going to get compensation for being a director, but you may receive compensation at large companies. New vacancies are filled by election, and they have to be held in accordance with state law and with the bylaws of the company. And the board has to be careful because it will violate its fiduciary duty if it manipulates the electoral situation so that it reduces shareholder influence. So they have to be careful about taking certain actions that would dilute the voting power of shareholders in certain situations. Because if it is detrimental to the shareholders to whom they have a fiduciary duty, then it is subject to a shareholder lawsuit. And that's something, obviously, the boards want to avoid. So in this context, there are a number of things that board members have to do in order to do their jobs, right? So along with these duties come certain rights, responsibilities, to sort of balance out their ability to perform their responsibilities. So here are a number of rights that attach to a board membership, right? For example, you have the right to serve your appointed term. If it's a year, then you have the right to serve for that year. Compensation isn't required, again, as I said. It's fairly common, a modest amount generally. You get other benefits from being on a board of directors other than simply being compensated well. You have a right to notice and participation in board meetings because that is where you manage the company. And if you're excluded from that right, then you're liable for what goes wrong and you have no influence over what happens. So you have an absolute right to notice and participation in board meetings, especially with regard to special board meetings, because those are non-regularly scheduled meetings of the board of directors, right? You have a right to inspect books and records, an absolute right to look at the transaction records and books of the company, all right? And you have a right to be indemnified by the company, which means that the company stands in your place when you're liable. And this is generally true unless, for example, there are circumstances under which, say, piercing the corporate veil would be appropriate. It would also be appropriate to deny the right of indemnification. Generally, this right is covered by directors and officers, insurance, which we'll talk about when we talk about officers and duties and what have you. Now, with regard to officers, corporate officers are agents. They're typically employees, although I've seen cases where a CFO or someone like that that's serving as an officer is an independent contractor in small companies. But they're generally agents, typically employees hired by the board of directors, right? The roles that are generally filled in most cases, you've heard those names before: president, vice president, secretary, and treasurer. Because these are employees, there are generally employment laws that cover them and employment contracts that will be applicable to them. The next the next thing that I'm going to cover are the duties of of directors and officers because they share direct duties. But before you do that, answer the prompt at the end of this video. All right, thank you.